Oh, the mic wasn't muted. Anyway, hi guys. Listen, I've been scrambling. I was scrambling the last couple minutes, so now I need to calm. And I was singing along with my little intro, and I forgot my mic wasn't muted. Things happen, you know. Hi guys, it's Kathy. I hope you're doing well. I got a lot of per se's today, so I'm gonna sprinkle them in between other crazy stuff. And listen, guys, I need you to try to exhibit a little bit of self-control when we get to Fleischer's courtroom, because I don't know if they dug a hole in front of his bench or what, but the people's heads in the camera start about here, and then they go down and down and down. I almost stopped the stream at one part and cut it out because I thought nothing was going on, and then I saw this tiny little head peeking out at the bottom of the screen. Yes, I've missed everything in chat so far, and I'm scared if I scroll back up, then I'll miss everything going back on. But hi, everybody. Everybody, including you, Elizabeth. Okay, let's start with, you know what? We're not going to start with per se. We got to ease into the per se's because they're just, everyone is unique. Yeah, yeah. I have nothing to worry about with this chat's self-control. But I promise you, even if you don't see a defendant in his courtroom, they're there. They're just tiny little people. How do you put someone this tiny in jail? Let them go home. Give them a lollipop. All right. Oh wait. Listen. If she wants to bark, she gets to bark. I don't yell at my dog, ever. She can do whatever she wants. We're going to start with Judge Frost. And yes, this is per se, but we're not looking at the per se person. That's not the problem in this. The problem is the other lady. She's so rude. She doesn't say anything rude, but her facial expressions during the entire hearing is out of pocket. And you know Judge Frost, he deals with a lot of drama cases, so he doesn't like to bring out drama. So he doesn't admonish her. But I think he should have. Okay, I'll go read chat when I put the video on. So nobody say anything funny because I can't put it on screen because I'm going to be scrolling the whole way up to read 100 messages. Ooh. I have too many animals. All right, here we go.
Morning, this is Judge Frost. I have one person calling in on a phone today. Could you let me know who you are?
Is this ending with 3122?
Yes.
Yeah, that is Komal Sharma from Sharma Homes.
All right. Can you hear me okay, Mr. Sharma?
Yes, I can hear you, Your Honor.
Wonderful. And Miss Kaiser, can you see and hear me okay today?
Yes, sir.
I don't know what your connection with the other defendants is, but is it just you there today, or are any of the other defendants with you?
It is just me, sir. Do I have the opportunity to explain?
Why don't you wait till I get on the record and then I'll let you explain. Yep.
Yep, okay.
This is case number 2024 SC 31, Sharma Homes LLC versus Rachel Kaiser et al. For the appearances today, on behalf of Sharma Homes LLC, I have Komal Sharma. On behalf of the defendants, I only have Rachel Kaiser today. Ms. Kaiser is by Zoom video. I've confirmed you can see and hear me, and I can see and hear you. Mr. Sharma is on the phone today, and I've confirmed he can hear me. And we're live streaming since we're doing your hearing by Zoom for you today. Ms. Kaiser, you were wanting to explain why the other defendants aren't here. Can you let me know what you have to share about that?
Yes, sir. I'm the executive director at Integrity Residential Services. Integrity Residential Services and Mr. Sharma entered into a business agreement to lease units from him. I personally, as Rachel Kaiser, outside of Integrity Residential Services, do not lease any units from Sharma. Neither do Jim and Tom. James Jorgensen and Thomas Miller are the owners of the company. So none of us have done any personal business with Mr. Sharma. As the executive director, I signed the leases for the company. And so I am here to represent Integrity. In the previous case, myself, James, and Thomas were all dismissed out of that case because we were not doing any personal business with Mr. Sharma.
Mr. Sharma, why are they sued as individuals?
So, Your Honor, thank you for giving me opportunity to speak. If you look at the doc number 30, let me see which was the latest one that I filed yesterday, which has the lease agreement. And doc 36, please. Can you open the doc 36 when you get a chance? Let me know, please.
Yep, I'm looking at it.
Okay, so this lease was signed. If you look in the bottom, let me see. I think I must have loaded the wrong lease because this is the one that is signed by Steve Lawrence. But the lease that was signed by Rachel is not by Rachel as the Integrity, but Rachel individual, Ms. Kaiser. So last time when we came for this court hearing, and I'm happy to upload the correct lease, they have left the property in a burned condition, and we are requesting the money for all the repairs that we had to do. April of 2019, Integrity has rented this unit from us. From 2019 to 2021, at that time, Mr. Lawrence used to be the in charge or executive director. We never had any problem. And as a matter of fact, if you look at let me bring the doc number.
Mr. Sharma, we don't need to get into all the details of the case yet. We're here for scheduling today. But I was asking that initial question to try to confirm why we have all these individual defendants. So, Mr. Sharma, are you the one that paid for a jury fee as well?
I paid for all the filing.
Well, when somebody made a de novo review, they also paid a jury fee. You made the de novo review, so I assume you paid the jury fee and want a jury trial?
I don't know if I paid the jury fee or I opened this case so we can have the hearing, and we would like to have the fair trial. That's the only reason I opened this case.
No, I get that. But on April 24th, when a demand for trial, let me actually double check this. Yeah, it says it was signed by you, by Komal Sharma for SHLLC. You filed the demand for trial, and somebody that day paid a $89 jury fee. So
I did.
Yeah, do you want a jury trial, or do you want me to decide the case?
I would only want you to decide the case.
Okay, so you're withdrawing that request for a jury?
That should be fine. Yes, Your Honor.
And Ms. Kaiser, is it safe to assume you're not asking for a chance to request and pay for a jury?
Yes, sir, it is.
Okay. All right, why don't we schedule a trial in front of the court then? Mr. Sharma, I know from your filings it looks like you're out of state. Are you planning to come in person, or are you asking to do this by Zoom?
If it's possible, I would like to have a Zoom, and let me know what date and time works for you for the trial.
And Ms. Kaiser, are you also wanting to be by Zoom, or do you want to come in person?
I actually, am I allowed to say anything before we schedule the trial? Is there any way to speak today to avoid that trial?
Procedurally, no, that's not an option. I'm not going to just dismiss the case today.
Okay.
If you wanted an opportunity to file a brief, meaning either a motion to dismiss or a motion for summary judgment, we could entertain that. But to tell you the truth, a trial would probably go more quickly than having you brief all of that stuff.
Okay, Your Honor, whatever you recommend, I fully support. However, I would ask that Sharma come down. Sharma lives in Minneapolis. He has been dragging me to court for months. I feel that this is an inconvenience to me, and he should be inconvenienced in the same way. I have to show up and I do just want to know that I have offered Sharma $3,500. He denied it.
No, but it was a lot of 3-letter words, so it was easy.
Told me he was going to take me to court, sue me for everything I was worth. He was offered a $1,500 then, and now we're here again. So I really am asking that if he insists on pursuing this further, that he is required to be present in person.
And Mr. Sharma, what would be the reason you need to be by Zoom since you filed the case?
Just because I'm out of town, but I can have. I'm happy to be at the court if I have to. I don't have any problem coming to Madison. May I speak one more sentence if I allowed to?
About what?
So what just Ms. Kaiser said, that she has offered $3,500. Actually, that is not a true statement.
Well, I'm not even considering any of that anyway. There's pretty strict rules that I'm not supposed to consider settlement discussion.
Okay.
So that's okay. All right.
Okay.
Well, why don't we, Ms. Kaiser wants to be in person, so I'm going to have the hearing in person.
Okay.
Do we think we need more than half of a day? So about 3.5 hours?
I don't believe we need that much time.
Her. Yell at her. Yell at her. I don't know why he named him Cooter. It's Cooter, Loaf, and can't remember the third name of the other one, but the other one doesn't talk to me anyway, so I don't need his name.
But, perhaps we should ask Ms. Kaiser.
Ms.
I
Kaiser,
need 5 minutes.
okay. Are you just going to have one witness?
Myself and one other person that has been forced to work with Sharma over the years, yes.
And Mr. Sharma, are you going to be the only witness for the plaintiff?
I might have 1 or 2 people, depending on the date and time we have that. So do you know by any chance what date that might be?
Well, we're going to pick that together. So we'll figure it out.
Okay. I appreciate that.
I'm looking at Wednesday, June 12th in the morning. It will be at 8:30 start.
Just to... Okay, did I hear the Wednesday, June 12th, 8:30 a.m.?
Yes.
I am okay for that.
Ma'am, does that work for you as well?
Yes, sir.
Okay. All right, we'll send out a notice with that hearing date and time. Do any of you want me to set any deadlines ahead of that, either to name witnesses or exchange exhibits with each other?
I apologize. I didn't hear that. One more time, please.
Do you want me to set any deadlines ahead of the hearing for exchanging exhibits or naming witnesses?
No, not Your Honor, no.
Ms. Kaiser?
Oh, sir.
Okay. So on that day, I need each of you to bring any copies of documents you want me to consider. Make sure you bring multiple copies, one for yourself, one for the other party. If it's a witness testifying about it, another copy for the witness, and then a fourth copy for me. So 3 to 4 copies of any document you want to bring and have somebody talk about. And then if you're calling witnesses, I'll expect you to ask them questions. So it'll be a question and answer with you and the witness. I'll also ask any questions I have, but I don't know what the witness is there to testify about. So I want you to ask them the questions to get them to tell me what I need to hear. We are not having a jury, it's to the court, and hopefully I'll be able to decide the case that day for you.
Your Honor, may I bring a lawyer?
Now, of course you can, yes. You're certainly allowed if you want to hire an attorney.
Yep. At this point, I feel like Mr. Sharma is really personally harassing me and personally stalking me personally. So I can't get away from this guy. So I do think I will bring a lawyer.
All right. And if that day and time don't work for your lawyer, the sooner you let us know that we need to reschedule, the more likely I have to grant that, okay?
Yes, sir. I will let you know right away.
All right. Anything else for either of you before I let you go?
No, that's it.
Thank you, Your Honor.
Okay, thank you both. I hope you have a good day.
Thanks, you too.
Yep, bye-bye.
Thank you.
She is not stalking you. I don't know. Guys, I just hope she loses. I don't know why. I don't care, but I just hope she loses. Oh. Okay, we're going to step away from pro se, and we're going to move on to a judge that I'm really starting to enjoy. I'm warming up to this guy. Now, he needs glasses or different glasses or contacts, so you won't see him a lot because he's reading his paper. He's reading his paper real close. His nose is like touching it. But here we go. Entitled. That's the name of this one. This one's called Entitled. You'll see why. That piece of paper is the judge.
Heard you watch the video advisement of rights?
Yes, sir.
Any questions about your rights?
No, sir.
All right. Charges here are 1 count of motor vehicle theft in the 2nd degree, class 4 felony. 1 count of criminal mischief, class 6 felony. Penalties are up on the board there. Any questions about the charges or the possible penalties?
Not right now, sir.
All right.
But
Are you willing to waive your right to a hearing and acknowledge the mandatory protection order that's in place?
Yes, Your Honor. We acknowledge the protection order.
I need to hear from him.
yes, Your Honor, I acknowledge the protection order.
You understand that means no contact, direct or indirect, or to stay away from her? You're not to have any communication by text, social media, phone, direct, obviously. You're not to direct anyone else to have communication with her.
Correct.
You're willing to do that?
Yes, sir.
All right.
I'm sorry.
People at the bottom.
Your Honor, based off the PC affidavit, we'd be looking to request a cash surety and property bond. It looks like Mr. Riddle is currently held right now in 19 CR 5706. Going through the history, it looks like there's another case of 20 CR 3711. We're concerned for the community's safety if he were to be released.
So he has 2 prior felonies still pending? Is that what you're saying?
Your Honor, they are not pending felonies. They're in revocation status is my understanding.
Oh, okay. Were those violent or non-violent offenses?
Your Honor,
Yes.
one is for a weapon and the other is for drugs.
Okay.
Drugs he used as a weapon.
Oh, all right, bond to be set in the amount of 4,000, I'm sorry, defense, I didn't ask you, what's your position on bond?
Your Honor,
Did Fozzie find out about the Mankini yet? Who is he mad at? List the names. We gotta know who we should protect. How mad is he? On a scale of 1 to 10, how mad is Fozzie about his Mankini?
we're requesting that the court follow the recommendations of pretrial services for a supervised fire bond. It does not appear that there were any threats made by Mr. Riddle in taking this car. My understanding of the vehicle is that it is shared property and that he did have access to the car as well. I understand that the PC affidavit, she is alleging that he did not have access to the vehicle, but in talking with Mr. Riddle, the car is shared property and he had his own set of keys, and that was what was used to drive the vehicle. Pretrial services did interview Mr. Riddle and are recommending supervised PR bond. I will note for the court, his CPAT score is at 7. However, he's given 7 points for essentially 3 occurrences, so that CPAT score actually should be lower. Same, he's given several duplicate points for similar transactions. So a CPAT score is quite elevated than what actually should reflect of Mr. Riddle's criminal history. Pretrial services spoke with him. They're recommending a supervised PR bond. They also noted that there was no weapon used in these allegations, that he would comply with any court conditions. He would comply with the mandatory restraining order in this matter. He also would appear in court as ordered. I don't believe there's any failure to appear history that would be of concern to the court, and I don't think there is a concern that he is not going to appear in court. I do understand that the failure to comply was filed in the 2 previous cases. However, he missed the first court date after that was filed. I do know that it's often the case that when that complaint it is mailed to the last known address on court files, it's often that they do not actually receive that notification that a complaint's filed. And so it's a pretty common occurrence that that court date is missed if someone has moved. And that likely could be the scenario here. Mr. Riddle also is a DoorDash driver. He's been doing that for about 3 months. So if he's to remain in custody, he loses out on all of the orders that he would have been driving for and receiving income for. He was also working with his brother on getting enrolled in classes. He is hoping to start classes in cybersecurity, and that enrollment deadline, we believe is coming up soon. He does not remember the exact date of that deadline. He just remembers that it was coming up, and he does need to get his enrollment packet submitted. He's lived in Colorado Springs for about 20 years now. His entire family does live here in the Springs. Without going into details, there is an incident mentioned in the PC affidavit in which Mr. Riddle is needing to get a doctor's appointment set up for and to have some things checked on. He's also been trying to get a doctor's appointment set up separate of this because it has been a while since he's seen his primary care physician, that he was hoping to do that soon as well. He does currently live with his mother and a couple of other family members here in the Springs. He has 3 children, ages 3, 4, and 5, that he does have 50-50 custody over. They do visit him often. They stay with him and his mother, and he also gives them financial support when he is able to. He can get a ride from any of his family members that live here in the Springs. He has access to a phone, so I don't believe missing court is going to be a concern for Mr. Riddle. He's also supposed to be taking blood pressure medication that he's not been given access to while in custody, and that likely could have complications if he were to remain in custody. Given that he is a DoorDash driver and a lot of his monetary income does go to those 3 children, he's not able to post a condition of bond. So we're requesting a PR bond in this matter. The court's not inclined for a reduced cash ready property bond in this matter, so that is potentially an amount Mr. Riddle could post.
Okay, guys, it's time. It's time for the judge to respond. I love this judge. I'm really, really warming up to him.
Ms. Bragg, are you on WebEx? My concern, counsel, is what you're telling me about this car is opposite of what's in the PC affidavit. That the cars are in Miss Bragg's name, that she's the title holder, and she tells the police he does not have access to these vehicles without her permission. And he's telling you it's like a marital property thing where you both have access to it?
Yes, Your Honor, my understanding of the vehicle is that it's both their properties, that they both used this truck.
No, I understand that's what he's saying, and that's what you understand. That's not what she's saying.
I'll address it. I would like to address this, but
I'll tell you my other concern in this case, Mr. Riddle. The level of entitlement that comes through this PC affidavit is striking.
Your Honor,
You take this car, you're in a relationship with Miss Bragg. You take this car, you go to Memorial Park, hook up with another woman, she catches you there. And the allegation is that they then start to follow you when you try and drive away, you stop and back up into her car. You got caught. And you don't like it. And I guess you think that that's okay for a guy to do.
that's not the facts. I understand what was said. Can I address the court for myself? Because, Your Honor, you've been told something that's not the facts.
Bond is set in the amount of $3,000, cash surety of property. Mandatory protection order is in full force and effect. Next court date?
June 3rd at 3:45 in Division EST. Oh, how?
So how much is my bond completely?
That's your bond, sir, $3,000, cash surety property.
And what is it for my other cases?
Talk to your attorney.
I'll have it.
People versus,
So in case you didn't listen because you were reading chat, which I understand, the judge didn't go to the defense attorney at all and said, bond is set at $4,000. And then he realized his mistake and he's like, oh, you can go. You can talk for a little bit. And after she was done, he actually did drop it to $3,000 after calling him entitled and saying, you think that's what a man should do? I thought this judge was great. Okay, we have to go back to the pro ses now because we've been away for so long. It's another roller coaster. Here we go. Judge Frost again, and one more Judge Frost after this.
Good morning. Attorney Johnson, can you see and hear me okay?
Can you hear me okay, Judge?
You were very faint at the beginning. Can you try talking one more time?
Is that any better?
Much better, yep. Mr. Glowaki, how about you? Can you see and hear me okay?
I see and hear you clearly. Do you hear me clearly?
I sure do, yep.
Thanks.
I'll call case number 23CV3110, Discover Bank versus Michael Glowaki. For the appearances today, who do I have for Discover Bank?
Attorney Joe Johnson, good morning.
Good morning, and I have Mr. Glowaki appearing by Zoom video without an attorney, correct, Mr. Glowaki?
You're correct. Good morning, Your Honor.
Good morning, and I have both of you by Zoom. I've confirmed you can both see and hear me. I can see and hear each of you as well, and we're live streaming, so we're doing your hearing by Zoom for you. And we're here on your request, Mr. Glowaki. We had a conference a few weeks ago, set a summary judgment briefing schedule, and then
Debbie, if you only know the comments I would get if I did that. Oh my gosh. When I explain something, the comments are brutal, The commenters love to tell me how much I don't know about anything at all. So yes, I'm going to explain every case from now on.
you had filed a letter the next day indicating you're hoping to stay that briefing schedule for a period of time to allow you to pursue discovery. Have you made any effort to start putting your discovery together to issue to plaintiff?
The request is my beginning, but the effort I put into is studying the statutes. I understand that chapter 804 is the relevant statutes. And
Sure. So you've read them, but you haven't typed up your request for production or your interrogatories?
I have not beyond my request for discovery. What I would like to do is I understand I need to be specific and clear, and so I'd like to begin making typing up my request for discovery, and then I also think that there's some of these things that I would be requesting would open up further questions of fact.
Well, certainly that sometimes does happen, that once you get some documents, it reveals additional things you should follow up on. So,
I would.
Okay.
Yeah. So are you asking me for me to talk about my request for the schedule? I wasn't sure if there's a question here.
Yeah, do you have an idea of how long you feel like you need to get that discovery out?
To do that, from today, I would like to request 60 days to make sure I can get it right. I hope that's reasonable.
That's a little long to issue initial discovery.
Okay. Okay.
Let me talk a little bit about, I think 60 days is perfectly reasonable in the sense that if you get the discovery out within the next 2 to 3 weeks, then the plaintiff gets 30 days after you issue it to respond. And then you need time to review it and decide if you need to follow up. So my thought would be that maybe we touch base again in 60 to 75 or 80 days. But the thought would be that you would have issued your discovery, received the responses, and then if you had additional discovery, you would have either issued it or be working on issuing that again by the next time we talk.
I would agree that's true. That I need some time to issue the initial discovery. So I think 30 days is probably more practical. I could get the initial discovery issued within 30 days. You said 2 to 3 weeks. I never done this exactly, so I'd like to make sure I do it correctly. And then I did want to ask if once I receive the discovery that I request, I would like the time to go through it, because there's a potential that there's a lot of information to review, and to make a second request for discovery based on the facts that I find, or that the plaintiff presents. I think there would be some additional questions that I've already anticipated in my request.
Sure.
And then you said that you'd want to touch base in about, I guess, in about 60 days to see whether I've received the discovery. Is that what you're saying? And whether I'm working on a second?
That was my initial thought. I guess I was hoping that when you filed your request, you would have been making a little more progress, but I'm not gonna throw the book at you or anything or hold it against you. So I'll give you 30 days to get your discovery out. Then we need to give 30 days for Discover to respond. So that gets us out. The 24th of June is the first weekday in about 30 days.
Okay.
And then we would get out another 30 days, gets us to the end of July. I would need to give you a couple weeks to review it. So,
well, you're saying 2 weeks to review it? That seems pretty aggressive. Like I would have to take, I'd have to devote all my time to reviewing the information I would expect.
Yeah, I'll just interject one thing from my side here, Judge, is, and I have no issues with giving Mr. Glowaki some time to issue whatever discovery he wants. But relatively speaking, this is a fairly simple case. It's a creditor-debtor case. It's a Discover credit card. The only claim is whether Mr. Glowaki owes on the defaulted credit card or not. So the issues here are pretty straightforward and limited. That is the only claim before the court. So any discovery would simply be to do with whether he had a Discover card, used it, whether he defaulted on it, and whether there's a balance due. So I don't anticipate discovery being very onerous here. The documents are fairly limited. The issues are fairly limited, but I'll give him whatever time he needs. But I mean, it's a pretty simple case.
Mr. Glowaki, I'm not sure, what are you imagining they're going to give you other than your account statements and maybe the original application you signed?
I'm disputing the amount, and some of the basis of my dispute of the amount is that there have been many data breaches, and I'm to my belief there's probably incidents where fraud has taken place, and I'd like to.
Have you ever reported fraud on your credit card? Because there's fairly detailed federal rules about reporting fraud on a credit card.
This is where Discover notified me about fraud.
Okay.
Yeah. I mean, and we can issue it. What he's saying, Mr. Glowaki, is generally speaking, you have 60 days to report an error on your billing statement. And if you don't do that within 60 days of receiving it, you waive the right to do it later on. So you can't go back now and say, hey, that charge in 2017 at McDonald's wasn't mine. You can't do that anymore. And we can argue about that. I'm just saying that's the general crux of the law.
That is, I don't know about those dates, but I do know there are very detailed rules under the federal code about all of those issues. So, okay. Well, Mr. Glowaki, I do think you should be able to review the documents they give you within a few weeks.
Okay. Could I request 3 weeks to review the documents so that I can also work?
Sure.
Thank you.
So we're going to put the date that we next talk. We'll put it in mid to late August if we have any openings then. When could we get them back on, Ashley?
Take a look. We could do August 22nd or September 12th.
What time are you looking at on the 22nd?
We could do 1:30.
That would be fine for plaintiff.
Mr. Glowaki?
Let's see.
I assume this is by Zoom again, Judge?
It will be, yeah. We'll be by Zoom.
Go to libraries. I don't think we have those here. Libraries. What's that? Oh, Carolyn. All the lurkers. Carolyn is saying hi yet again to you. Every day. Every day she says hi to you.
22nd, that's fine.
Okay. We'll get out a notice with that day and time. And again, Mr. Glowaki, what I'll expect at that day is a detailed explanation from you if you feel like you need more time about what exactly you're following up on, how you are in the progress of getting more discovery issued, and why it's relevant to summary judgment. So, or if you've reviewed everything and we're ready to go, then we'll pick the new briefing date for you to submit your response brief. And I would give you at least 30 days to respond to that. But if you start working on it ahead of time, if you feel like you got all your discovery done, use that extra time to start drafting. Okay.
I wanted to make sure I got the intervening deadline. So you said June 24th. The other one would be, you said July 24th.
Okay. They're not deadlines, but that's why I'm building in this time. Is the plan is that gives you 30 days to issue discovery, 30 days for the plaintiff to respond to it, and then a few weeks for you to follow up. If we get to that date of our next hearing and Attorney Johnson tells me you didn't issue discovery until 50, 60 days in, and that's why we haven't made any progress. I'm going to need a good explanation from you. So those were just dates that I threw out there so that we could figure out what's 30 days for you to work on your discovery requests that you want to issue. Where would that get us 30 days out for them to respond? And how do we build in some time for you to look it over, okay? So don't consider them hard deadlines, but you need to move as quickly as you can on everything, okay?
Yeah, I do understand that. All right, so that works. I appreciate that. And I wonder if the attorney for the plaintiff, I'm open to doing mediation. I don't know if that's something that you are willing to do.
And I know you called, I think you talked with Attorney Kellum in my office maybe a little bit ago, Attorney Glowaki, and certainly between now and the next court date, we can talk and try to work something out. And if we do, that obviously moots out all of this. And, if we work out some sort of settlement or some agreement.
Yep. And I never force parties to mediate, Mr. Glowaki, but you're welcome to keep talking with attorneys for plaintiff to try to reach a resolution, okay?
Thank you very much, Your Honor.
And I'll just explain it. If you choose to do mediation, the Dane County Bar Association has a program where volunteer attorneys volunteer half a day to mediate cases for free. You pay $100, I believe it is, per side, and that's just an administrative fee for covering the administration of organizing that, and that goes to the Dane County Bar Association. But you get a value of $1,500 of attorney time for free. So if you choose to mediate, that might be a very cost-effective option.
Yeah, I'm strongly considering that. And do we both have to agree to do that?
Correct. You have to agree.
Yeah, and I have no issues with that, Mr. Glowaki. Usually I would say we should try to talk it out amongst ourselves just to save us each the $100. And then, if we can't work it out amongst ourselves, then mediation can sometimes facilitate it a little better. But it's always worth talking, having a conversation with myself or Attorney Kellum in my office. Doesn't cost you anything, and we might be able to get it done. So
I would like a conversation with him in his office, and I would like it to be for free.
Yeah, I think that there could be progress made in either approach. I would like to continue to discuss the option of mediation and schedule that. Do you need me to inform you, Your Honor, that we're doing that?
You don't have to, but if both of you agree you want to mediate and you'd rather put off discovery or put off briefing so you can get that done, if you let me know that, we would pause the case to let you both pursue it. But that would have to be by mutual agreement.
Of course.
Yeah.
Okay.
Thank you.
All right. Well, I hope the both of you have a good rest of your day, and we'll see you in a couple of months.
Sounds good. Thanks, Judge.
You're welcome.
Bye-bye.
I'm curious to know too. Is she singing that song now? My baloney has a first name. You have to learn how to sing that song now, Carolyn. Donald, did you just say last time you tried to make a bologna sandwich, you ended up making beef Wellington? I don't know if that's what you said, but in my head, that's what you said. What? You ate fried bologna for the first time last month? I grew up on that. Anyway, I want to give a great big shout out to Gloria Scheidler. Thank you for upgrading your membership on my Patreon. I really appreciate it. Thank you. Okay. Next, we're going to Georgia, I believe. Not pro se. Thank goodness. My goodness. It's just judges arguing about technicalities, which is the judge is just like, he doesn't rule, but you can tell that he thinks they're dumb. That's how I remember to spell baloney too. And then when that song came out, Carter was president, And there was that song, I don't remember. But I both of those songs I used to sing all the time when I was little. Yeah, actually the brewery that I work at I think it was like 2 weeks ago. I can't remember. My days blur together. We had a special for like the weekend fried bologna sandwich. So I'm like, oh, hook me up. Yes, I want that. And I took a bite out of it, and it was like warm bologna. Like, that's not fried bologna. Fried bologna is like fried, like, black, just like my dad used to make black. No, this was professionally made, so the bologna was cooked right. No, that's not fried bologna. Come on. I ate it anyway. All right, serious bodily injury coming up in 5, 4. Here we go.
All right, are we ready?
Yes, Your Honor. This is State of Georgia versus John Quez Jackson. It's a preliminary hearing on page 4 of the clerk's calendar.
All right, you may call your first witness.
State calls Sergeant T.J. Farthing.
I just want all the New Yorkers out there to know you can go ahead and put this speed back to normal, because you're going to be fine with this guy. Actually, you're going to have a hard time keeping up with this guy. And if you have it on double speed, you don't stand a chance. Even you New Yorkers who like it fast, 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 don't stand a chance with this guy. So slow it down. Here we go.
You got a copy of the warrant. Thank you. You raise your right hand to use for the testimony you're about to give in the case now in hearing be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
All right, please have a seat.
Good morning.
Good morning.
If you will, please state your name for the record.
Thomas Farthing,
And how are you employed?
sergeant with the Washington County Sheriff's Office.
How long have you been with the Washington County Sheriff's Office?
5 years.
And what are your jobs?
Tell me you've never smoked pot without telling me you've never smoked pot.
And responsibilities with the Washington County Sheriff's Office?
Night shift supervisor, over road patrol, and then answer calls and as needed as far as traffic enforcement, regular calls for service, and supervising the rest of the shift.
Are you post-certified?
Yes, ma'am.
How long have you been post-certified?
21 years.
Are you familiar with the defendant in this case, John Quez Alonzo Jackson?
Yes, ma'am.
Did you have occasion to take out warrants against Mr. Jackson on or about November the 9th of 2023?
Yes, ma'am, I do.
And would those be for obstructing or hindering law enforcement officer, serious injury by vehicle, fleeing or attempting to elude, possession of marijuana with intent to distribute, items prohibited for possession by inmates, crossing guard lines with weapons, intoxicants, or drugs without the consent of the warden, and trading with inmates. And I realize that you may have not taken out all those warrants, but are you familiar with all those warrants being taken out for this defendant?
Yes, ma'am.
If you will, please tell us how it is that you came to be involved with this case.
Yes, ma'am. On November 9th, a little bit after 11 o'clock, I was notified by GDC K-9 unit, Andrew Lyden, said that they had received GDC info that a drop was occurred at Washington State Prison. At that time, Captain Bergman was working in prison detail. I called him, give him a heads up. As I was talking to him on the phone, he said, well, while I got you here, the drone's flying over right now. I told him, okay. I said, I'm on the way down there, proceeded down there, turn on off 88 on Spark Davis Burrough Road. They didn't have, at the time, they didn't have a vehicle description or anything like that. So as soon as I turned down, I saw a slow moving Charger going about 15 miles an hour. I mean, there's on that stretch of Spark Davis Burrough, there's no vehicles, there's nobody, there's no really too many residents to be down there just to be slow rolling. I passed by, didn't have no emergency equipment on, passed by the vehicle. Well, the vehicle saw me. It started accelerating rather quick. I heard the engine go automatically into a quick acceleration. I turned around and attempted to catch up the vehicle. Once again, I didn't have no emergency equipment on. Activated my front antenna on the same direction on my radar. It was 55 miles on. I locked in the charger at 75. I proceeded to catch up. As I was catching up to it, it looked like it appeared that he saw my head. So he accelerated, kept on quicker, got to the intersection of South Sparta 88, took an immediate left-hand turn, and once again could hear the engine quicker accelerate. I got on 88. As soon as I got on 88, I observed the car turn off all its lights, proceed down the roadway. Started passing by 18-wheeler and stuff with no lights on. Then turned his headlights back on. I had activated my emergency equipment. Light sirens completely activated. He kept on proceeding. Went down towards Sandersville, turned around at Jordan Mill Pond Road. Still, once again, license sirens, fully audible. Marked patrol unit. No excuse not to know his law enforcement behind. Kept on accelerating. Got to back to Highway 231, South Sparta Davisboro Road. Started having backup units that was able to catch up. As with his driving and stuff, not caring, he done passed by vehicles, passed by 18-wheeler. Had no sense of care in the world, it seemed like. I made contact right before Jefferson County Bridge with the vehicle and intended for a pit. Saw where I was at, disengaged from that pit. He continued to accelerate. I re-engaged after I got past the bridge right in Jefferson County. Before the pit, the vehicle spun, then overturned, and in which case Mr. Jackson was on the driver's side of the vehicle. Passenger of the vehicle was ejected from the vehicle. Secured Mr. Jackson, but backup units got there. After I secured him in handcuffs, I went and checked on the passenger. I rendered aid to him, brought him on the side, called for EMS, called for other units, which time Mr. Jackson was taken to the ER in Jefferson County. The passenger was airlifted from Highway 88. The vehicle itself, when I called the tag in, showed that it was a rental vehicle. So that was another indication that there was a reason for being in the middle of nowhere.
What information were you able to discover about the driver of the vehicle once you ran his information?
Once it showed that he had outstanding warrants for previous encounter with law enforcement for aggravated assault on a law enforcement officer.
And were there also outstanding warrants for possession of dangerous drugs and felony items prohibited by inmates in Tattnall County?
There was.
You may have mentioned this. What was the highest rate of speed that you clocked the defendant?
The highest rate was at 120 miles an hour.
The drugs that Mr. Jackson has been charged with, did you discover those or were those discovered by another officer?
Those were discovered in relation to the prison of the drop being performed. Was found in the car was drone in relation to the same one that Captain Burgomy saw flying over the prison.
So the drone was actually in the vehicle?
It was.
Okay. And then the drugs were associated with the area where the drone had been seen earlier.
Correct. It was, the drugs and the other contraband that was found on the premises of Washington State Prison.
Thank you. We'll pass the witness, Judge.
You may cross-examine.
Good morning.
Good morning.
My name is Gina Carr, and so you said that you had gotten a phone call that y'all had gotten some early information that a drop was going to occur at the prison.
That's correct.
So you followed that up and basically called Captain Burgomy, and you were told that the drop was actually going on right then.
It was supposed to be in the process. GDC had gotten notified. GDC notified me. Captain Burgomy being the one that was working that detail at that time, I went ahead and notified him since he was already on that immediate area.
Okay. And so you started patrolling the area near the prison?
Yes, ma'am.
Okay. And the only vehicle near the prison at all at that time was the Dodge Charger?
Yes, ma'am.
And, or just on your road, or were there other roads or other places that?
There's other roads, but the only vehicle in that area from the direction that was flying from the drone was that Dodge Charger.
Okay, and I'm a little bit confused about the timing. So basically, you started patrolling after you already knew a drop had occurred.
No, ma'am. I started easing to that area as soon as K-9 Officer Lyden called me. I went ahead to that area of Davisboro.
Okay, so if that drone is indeed the drone that was used in the drop, because there was a drone found in the car, correct?
Yes, ma'am.
Okay, you started out patrolling, looking around the prison for anybody that might be, some suspicious activity related to the drone, correct?
Yes, ma'am.
Okay, and then the drop happened. Can you tell me if the drop happened after or before you spotted the car?
Well, the time frame from the time that Captain Bergman said that he saw the drone was about delayed enough, about 20 minutes or so, for it to be enough time for the drone to land and for them to be leaving the area.
Okay, but you were in that area when all that would have happened, correct?
I was in the area of Highway 88, which was approximately 4.
Yes. So there was a couple cases in front of this judge today, and it wasn't the same incident. I think actually there was one in front of another Georgia judge today too, where they got caught with drones. So they take these drones and they drive like 5 miles an hour, like, a couple miles away from the prison, and then they drop the drugs in from the drones. So the one lawyer was saying there was no probable cause to pull their defendant over because they saw him go to a drug house, and then they saw him park in a field, and then they saw the drone, and it was near the prison. So she lost big time. I mean, her whole case was about Miranda, and she's talking about being arrested, and nobody questioned this guy. And it was crazy, but it was all about drones dropping drugs into a prison. And this guy, allegedly, everybody is innocent until proven guilty. Allegedly, put some drugs into the prison. They found the drugs in the prison and in the car.
Miles from the actual prison itself.
Okay, and I'm not that great with military hours, so 23:27 is 11:27 p.m.
Yes, ma'am.
And you're saying that my client was the driver. Were you able to visibly see him as the driver, with it being that it was at night? And I know he did a U-turn, but how can you identify that he was actually the driver?
He was the same size, height. The passenger was was a lot smaller, taller. There was only 2 people in the vehicle. There was only 2 people on scene. He was crawling out from that side of the vehicle.
Well, it says in your report that he was crawling out from the passenger side.
Yes,
not the driver.
because the vehicle was upside down.
Okay. Did you see the passenger, the alleged passenger? Did you see the other person in the car get thrown from the car?
Not initially, I did not.
Okay. With the way the car was wrecked, was the only exit out of that car the passenger window?
Yes, ma'am. From the video evidence shows the way that the passenger was ejected from the vehicle, that he was in the passenger side of the vehicle.
Are you saying that the driver's side was?
Yes, ma'am. When the vehicle started overturning, he came out the front windshield of the passenger side.
Okay.
I was able to verify that once watched the video of the in-car camera.
Okay, which I don't have at this time.
Yes, ma'am.
All right, and now one of the things we're here today is with serious injury caused by a vehicle. Do you know if the condition of the alleged passenger or the other person in the car, if he lost or injured any member of his body, any organs? Do you have any idea of his medical condition?
As far as his medical condition, I'm not aware. I know that in December, he was still in the intensive care unit at Madison Health. And I'm not a medical doctor or anything, but the passenger was coughing up blood and non-responsive.
But obviously not a broken back, or because you said you were able to move him so that he would not choke.
I rolled him over to a side of recovery position because he was gargling. That was just a safety measure to do as much as I could for him.
Correct. And any visible signs of any broken bones or any kind of, like I said, broken back, broken neck, anything like that?
That, as far as any kind of compound fracture sticking out at night, no, ma'am, there was no way to see that.
Okay. And as far as you know, y'all don't have any follow-up medical records at this point in time?
No, ma'am, we do not.
Okay. But you said that you understood that he was in ICU till December. And do you know if he is out of ICU now?
No, ma'am. Like I said, last I heard was in December, and he was on a ventilator and a feeding tube.
Okay. So going back to the pit maneuver, you went to perform the pit, and that was when the vehicle, to avoid the maneuver, lost control?
No, I disengaged. I made contact to begin with and the initial pit, and then I realized exactly what area it was, and I did not want to take the chance of putting him in the area of the bridge. So I disengaged, and also that also gave him enough hearsay to, okay, I need to give up, but he didn't. He continued on.
Okay. And during all of this, I know it started a little bit later, but you did engage. You were in a marked vehicle, and you had your lights and siren on.
Yes, ma'am.
Okay. And but just to make sure, you believe that it's my client who is the driver, just based on observation with the size of the passengers in the car.
Asked and answered.
With the belief that with the belief of the person who got ejected from the car, that he was ejected from the passenger side.
Correct.
Okay. Thank you.
Anything else from the state?
No, Your Honor.
You may step down.
Thank you.
Any other witnesses for the state?
No, Your Honor.
Any witnesses for the defendant?
No, Your Honor.
Any argument?
Your Honor, fleeing is very broad, and it's one of those things that if you have a marked vehicle that has the lights on, and honestly, the way that they've rewritten the statute, it's not even a matter of reckless driving. If it results in a wreck, it's considered felony fleeing. I definitely think there's probably
120 is also felony fleeing.
Well, that.
Yeah, that too. Yeah.
Even if you had an argument about that. But, and I would say that, that definitely there's probable cause to bind that over to the grand jury. But I don't think at this point in time, without any more information on the injury, that we're really talking about serious injury.
He's on a ventilator and he's been in the hospital for a long while. That seems like serious injury to me.
No,
he may be looking at felony murder.
Well, he's out of the hospital now, and from what I understand, and I'd like to know some more about the medical, or if they ever go to the grand jury with those charges, I'm hoping that they would have those with them, because the statute is very specific that you have to deprive someone of, a member of their body, and or a disfigurement, or it has to be serious, like it says, serious injury caused by a vehicle. And I think that just having a wreck and having to go to the hospital is not enough to bind that charge over to the grand jury.
Well, of course, I don't bind it over particularly charge by charge, although I think it is, if he was, based on what the officer observed, he was gurgling blood. That's, to me, that's serious bodily injury. So I think there's certainly sufficient to bind the entire matter over to the grand jury, and I'll sign an order.
Thank you, Your Honor.
We have one other matter for Mr. Jackson, and
serious bodily injury is that lawyer wearing sneakers in the courtroom. But yeah, her thing was, okay, all these charges are good, but not the serious bodily injury. That we won't stand for. That's bad. No, I didn't see that yet, Carolyn, and I'm going to get in trouble if I don't watch it soon. That's a fact. All right. Now we're going back to a pro se, guys. This will be the end of the pro se parade for today. But don't worry, there's always more pro ses coming. Your sound is fine. No one's talking, guys. Your audio is fine. No one is talking.
Good morning, Mr. Laufenberg. Can you see and hear me okay?
Yes.
Great. Let's get started. This is 23 CV 954, State of North Dakota doing business as Bank of North Dakota versus Steve Laufenberg. Who do I have appearing for the plaintiff today?
Michael M. Jereminski, Special Assistant Attorney General for the State of North Dakota.
Thank you. And then I have Mr. Laufenberg appearing without counsel today. Is that correct, Mr. Laufenberg? You're still representing yourself?
Yes.
All right. And I have both of you by Zoom video. I've confirmed you can both see and hear me, and I can see and hear you as well. And we're live streaming since we're doing your hearing by Zoom for you. Mr. Laufenberg, we're here because you filed a motion to vacate judgment. And I guess, as I understood it, I guess I don't even honestly follow what you're saying. So you said something about that you did not receive a notification of any sort of summary judgment terms. What does that mean? Did you not get a copy of the motion and the brief that plaintiff filed?
No, I haven't heard anything since the new attorney has been to the.
Is he in a library or is he at Diana's house? Diana, you got some explaining to do.
Case.
Okay. So did you get the briefing schedule that I sent out to you back in November?
The last thing that we had was the last Zoom conference. That's the last thing we have.
Yes, I understand that.
And then oh yeah, you sent a paper of you were going to send it into judgment, or
okay, Mr. Laufenberg, just wait a second. Do you have any of the paperwork in front of you?
I'm not very organized at the moment.
Well, if you don't have it, that's fine. I was just asking.
Okay.
So the day that we had our last conference, we picked dates. You were on that conference. I talked to you about the dates for the briefs to be filed. I sent out a notice of briefing schedule with a standing order that same day. So that would have had the 3 dates for different briefs to be filed and some other paperwork explaining what it should look like. Did you get a copy of that, which the court would have sent directly to you?
Not for briefs, no.
Okay, sir, what's your mailing address?
2703 Birchwood Pass.
And do you regularly check your mail at that address?
Yes.
So we mailed that out to you November 9th. That should have come to that address within a week or so of that date. We mail everything to you since you're a unrepresented party who's not an electronic filer. And then shortly after that, plaintiff changed attorneys. They filed their motion on January 16th. You're saying you never got a copy of that?
November 9th, January.
Well, they filed an affidavit of mailing that says on January 19th, they mailed an authenticated copy of it to you. Did you get a copy?
I don't have anything in my file that sounds like that at all.
All right. Well, what I'm inclined to do, Attorney Jaraminski and Mr. Laufenberg, is to give one more opportunity for Mr. Laufenberg to file a response brief. We will remail out our briefing schedule to him, although I'll just have to do a new one with a new date and time for his response to be due. Attorney Jaraminski, I'll ask you to mail one more time, mail him a copy. And Mr. Laufenberg, frankly, at this point, if you don't get it within about 7 to 10 days, I'm not going to use that as another excuse if you just don't get anything and then don't follow up with Attorney Jaraminski and try to make alternative arrangements. It's okay that you receive service by mail, but if you don't adequately check your mail, if you don't pay attention to what comes in through it, that can't be an excuse to delay the case forever. So I need you to follow up as well. And if you're having a problem with the postal service, you need to figure out some alternative way to get it, whether it's by email or coming to the courthouse and getting a copy. Do you understand that?
Yes. How do I get the other attorney's new information?
Okay. You said that you got all the paperwork when they substituted attorneys. Do you not still have that?
I said it. Last thing I remember having.
Do you have a pen and paper?
Yeah.
Attorney Jaraminski, would you mind giving him your phone numbers that he could reach you at?
Certainly, you can reach us, or you can reach me at 319-234.
Okay. Have that written down. Thanks.
All right. So, Mr. Laufenberg, what I'm going to do is I'm going to assume that you'll get the mailed copies in about a week, the Postal Service with the holiday.
Sorry, Judge Frost reminded me. I have a P.O. box now because you guys said I had to get one, so I got one, and it's in the description of my channel. All right, here we go.
I think it'd be unreasonable to expect it to come any sooner. So I'm going to give you to receive everything in the mail until the end of next week. We'll put the deadline for your response brief and affidavits at the end of June, which is the weekend. So we'll actually call it July 1st. So you should have about 30 days to get your paperwork together, your brief, and any submissions you have. And then Attorney Jaraminski, is 15 days after that enough for you?
Yes, Your Honor.
All right, so we'll put July 16th for a reply brief. I will vacate the judgment that I entered, and we'll wait for those additional submissions. And again, Mr. Laufenberg, mark your calendar. Make sure you check in your mail. If it's been by the end of next week and you haven't seen anything, follow up with Attorney Jaraminski or the court or both, and let us know right away that you haven't seen anything, because we'll need to figure out what's going on.
Okay, I certainly will.
Do you have any questions for me today?
No, that's it. Thank you. No.
Okay. Attorney Jaraminski, anything else for you?
Mr. Laufenberg, would you like me to mail you the summary judgment packet again? And then we can.
Is that in conflict of what we're doing right now?
And I was anticipating you would mail that to him because he claimed he never saw it.
Okay.
Even I know we had an affidavit of mailing, but he said he never received it for some reason.
Okay. And we'll send it to the Cross Plains address. I'm sorry, Birchwood Pass in Cross Plains, apartment 2.
All right. Okay, thank you, everyone.
All right, thank you, Your Honor. Have a good day.
All right.
Both to you as well.
Okay. And where are you sending me, Your Honor?
What the court will send you are the new dates for the briefs. So the one that you need to file by July 1st and the reply brief by July 16th and my standing order on summary judgment. Attorney Jereminski is sending you his initial motion brief and supporting paperwork. That's what you're going to respond to by the July 1st date.
Okay. They're responding. Okay.
And at this point, if you have any questions about how to respond, you're going to have to pay an attorney to help give you some legal advice or do some research online about how to respond to summary judgment under Wisconsin law.
Sure.
I think I've shared as much as I can about the procedure and process.
Sure. All right, then. That's fine. Thank you.
All right. Have a good day.
Thank you. You too.
All right. Thank you.
You're welcome.
Bye.
The judge is gracious because he's very used to, crazy. He's very used to crazy. What else can I say? All right. It's time. It's time for Fleischer. I'm putting him on. Remember, I need you guys to show some restraint. because everybody that comes is going to get a little bit shorter until you see this tiny little head popping out. Not all of them are. Some of them fit right in the camera, guys. I promise. But not many. And again, it was a real long docket. Yes, Carolyn, restraint. Google it. Google it, Carolyn. Google it. So, and I'm stepping away for 3 minutes. So I'm leaving you all alone for the first one. And I didn't see it, so I don't even know if it's any good or not. Hopefully it's nothing that I needed a graphic warning for, my lord. Here we go.
Going at 100 miles an hour.
It is
Always. Nothing changed.
I'm wrong. I'm always wrong, but I'm wrong. Guys, I got some... Carolyn Googled it, guys, and it was weird. I got some great news for you. Get ready, guys. That's yesterday's stream. At the very, very, very end of the stream, Judge, and is it Pavel? Is that the prosecutor's name, Pavel? Judge and the prosecutor were talking about, do you have to register as a sex offender on a second offense? And I said we're never going to hear the answer to this because they turned the feed off. Here we go.
Okay.
My first is David Romero. That's the one you want to reevaluated for the IOP SOP. I think he was in yesterday. Nathan's okay with him continuing the program being extended.
Okay. So, let's do this in baby steps because I'm not going to sit here and reset this thing for another 6 months, 2 months, 5 months, just waiting for him to get stuff going. Let's go. So what's the first thing he has to do? He has to do IOP, SOP?
He has to do SOP.
Okay, so let's do this. Come up, Mr. Romero. So the first thing that we're going to do is that you must have the DWI education class done within 30 days. Okay. The other thing is I would say have him enrolled in the IOP or SOP within 2 weeks. And let's come back and make sure that he's got enrolled and at least see what kind of course you're on. And we'll go from there. I want the education class done within 30 days. And then within 2 weeks from today, you must be signed up for the IOP and you start doing that as well.
Yes, sir.
If you ever test positive for anything, I will immediately set your case for trial. I don't care what it is. I don't care if it's mouthwash, a tequila lollipop, hair dye, whatever it is. You're on notice. Any positive blows for whatever it may be, it's over. Do you currently have an interlock now in my vehicle? Okay. All right, and then let's just go from there. And
2 week reset, Judge?
so yeah, for now, 2 weeks, just as we can show that he's enrolled. You can come here. If you can prove to me that he's enrolled and that he's starting to attend classes, I'll waive the appearance. Okay, but you must be in hand prior to, and then, 30 days to get the education class, and then we'll go from there. Okay, good luck, Mr. Romero. Thanks. All right, so just go ahead, take a seat, and Shatori will call you up here momentarily. That's fine.
Next is a BVR and Felix Murillo Jr. If you don't have a copy, I have one for you right here, Your Honor.
Please, somebody remember that name. Because when Victoria comes on and we ask her who the new person is and we don't have a name to give her, then, we just all look silly. Just like yesterday, we just all look silly. Shatora. Hold on, better type that. I'm just going to write it down and then I'll know. And of course, I'm going to spell it wrong. But now when Victoria comes in and we say, who's this new person? And we have a name now because we're professional. Very, 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 very professional. Oh no, what did she put? What did she say, Carolyn? Did I miss it? How did I miss it? Because yesterday was so long ago. What is she? Do you know? Is she what is she? What position? No. Anyway. They're going to get candy today. I sent sweet tarts and 2 different kind of lollipops. Lollipops and sweet tart lollipops. And they're going to get it today. They literally are on the 9th floor. They're up high.
Can you bring him up, please?
Jr. Felix Murillo Jr. Okay. And Your Honor, may I explain kind of what happened here, Judge? Sure. So he has a portable device on this, Your Honor. He sometimes works nights in different hours. During the times of the violation, his boss did not let him blow. He blew immediately after. He had no violations. I asked him now if there's an issue with the blow schedule as it is. He said there is no issue now. I said, can there be an issue in the future? He said, well, there can be if the big boss comes in and needs him to work different shifts. I told him that he needs to make sure he speaks to pretrial before that happens, not after. He fully understands that and what the consequences will be if this happens again.
Fozzie knows everything.
I'd like to know the times that he's not blowing. You're trying to tell me it's because of work?
It's because of work, but his schedule changed back again where it's not an issue. He knows his schedule.
I would like to know what the blows are, what he's not doing. Because if you're not blowing at times that you're not working, I'm going to put you in jail. Take a seat for me in the jury box. I'm not ready to make a decision on you yet. Tracy, on Mr. Murillo, can you pull up the times that he's not blowing? Please, I think they say he has 6 skips. All it says is here, it says 6 skips between 4:18:24 and 5:21:24. It does not tell me the actual time the skips are. Or is it at 5 p.m.? Is it at 5 a.m.?
So his shift during this time wasn't consistent, and that's why this was an issue. But you'll see he never blew positive for alcohol. But
he's not blowing.
Yes, he is now, though. And he knows
I don't care now. I care about them.
Yes, Judge.
So I'm not ready to make a decision on that. What's next?
I have an arraignment.
Okay.
So I'll come back to that. Thank you.
Who's your arraignment?
My arraignment is Jose Alarcon.
Alarcon. Okay. And you're telling me he's not here yet?
He is here.
He is. Oh, you need to. On his way. Okay. As soon as we get him, just hang tight. As soon as we get him, we'll do it.
Okay.
We'll get you first.
I'm going to do a walkthrough and 9 and come right back.
Go for it. Take your time. No rush.
Hey, Judge, on the duty to register, you were right about the indecent assaults. It's only on indecent exposures. multiple indecent exposure.
which is a shame. You know, it doesn't make sense.
Actually, the other one is more violent.
Oh, right. And perhaps at some point the legislature will get it and they'll amend it to make this a registration requirement on a second, you know?
Yeah, but indecent exposure, when we charge it as a second, we charge it with a prior, that's automatic registration.
Interesting how this one's no duty to register.
Yeah.
Not yet.
There's multiple indecent exposure provisions.
There we go, guys. They answered. Hello. They answered our question we thought we'd never get answered. Just let me tell you how busy Judge Fleischer was today. He's about to take a drink, and then I'm about to cut the video and cut a gap. I cut a gap this tiny, and I didn't cut any other gaps out of everything you're seeing today because it was one after another, after another, after another, after another. And then after a while, after this little tiny head popped up, I had to say stop. And there was still a whole bunch left that we don't get to see today. He was busy today. Well, yesterday. Now today is Friday. So he's going to be busy today too.
I'd love to reach out to this officer and see if he has a.
It's okay, please. Good morning, Mr. Brown. Sir, you're charged with assault bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer, the lawyer will be appointed to represent you, sir. Okay.
Yes, Your Honor, on May 9, 2024, the complainant is an employee at S&J Tire Services, Harris County, Texas. Got into a verbal argument with the defendant. The defendant threw a 13-inch wheel tire at his face. And the defendant felt pain.
He got hit by that?
Got hit in the face with the tire.
Ow.
Tire iron?
The tire, the actual tire.
The actual tire.
The actual tire. The defendant remained on location. Surveillance is consistent with the complainant's statement. Did speak with the complainant. Still experiencing pain, migraines at this time.
Hospitalized?
He wasn't hospitalized. He did have a busted lip and bloody nose.
So what is the relationship? Was he an employee there?
He had purchased the tire from the location approximately 3 weeks prior.
Okay.
He came back stating that someone told him that it was defective and arguing with the guy. The guy told him that he was just an employee, said that, there's no refunds, what have you.
I understand. Okay. All right. So, Mr. Brown, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go back to this location. Do you understand? I'm also ordering you not to have contact with the complaining witness in this case. If you violate these conditions, I will put you in jail. You will not get any more PR bonds. Do you understand?
Yes, sir.
What do you do for a living, sir?
I'm an Uber driver.
Do you have a Texas driver license? Do you have valid liability insurance in your name? You may continue to drive, but if you don't have a license, if you don't have insurance, then you cannot drive as well. I am also going to make that a bond condition as well. How much money do you make a month, sir?
Oh, 1,800, sir.
Who do you live with? How old are you?
23.
You're 23.
Yes, sir.
And who do you live with?
I live with my mother.
Can you afford a lawyer?
No, sir.
I'll have you fill out an application for me. Well, I'll take a look to see whether you do qualify. If you do, I'll grant you a lawyer today. If not, you'll be required to go hire a lawyer for yourself. I don't want any more issues. Don't pick up any new cases. You understand? Okay. Deputy will give you an application. I'll have you go sign a receipt with Victoria. After that, I'm going to have you take your seat in the jury box while I get your bond conditions. We'll have you sign it. And after that, if I give you a lawyer, you'll have to stay. If not, we'll let you go hire one. Please. Wonderful. So can you file a no contact and no weapons and no going back, please?
Go ahead and sign for your reset. All right, Judge, page 4, Burrough.
Le Christopher.
you done with it? Just read it.
Hey, Vel, I see that he's on probation for a felony evading. Was the warrant issued prior to this? Was he mucking up prior to this case, or was this the case that you?
It doesn't appear so. It looks like, so this offense was 516. They filed a warrant 521 based on a new law violation.
Okay.
I love his shirt and his jacket.
Actually. First one.
Like Christopher Burrows. I love the name, but I don't like your game. You're now charged with evading arrest again. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. We took you into custody now because the felony court issued a warrant for your arrest. You're on probation, not supposed to get in trouble. When you do, there are serious consequences, as you now see. So we're going to do probable cause. If I do find probable cause, I'll give you a lawyer today, and they'll help you explain what's going on.
Yes, Your Honor, 5/15/2024, officers conducted a traffic stop on a Block 4 Fusion in the 1400 block of Cool Springs Drive in Harris County, Texas. And that was for an unreadable Texas temporary tag that was on the rear back windshield. Officers observed the driver exit the vehicle. Officers advised the driver to get back inside the vehicle. And the driver then fled on foot, running approximately 60 yards, going into a backyard and jumping over a fence before he was apprehended.
Got it. Mr. Burrows, do you have a Texas driver license?
No, sir.
You were not allowed to drive. I don't care what your excuse is. You will with me today sign an affidavit promising me that you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive, I will have a contempt hearing. You'll be facing an additional 6 months in jail every time you drive. So if you drive 5 times, I'll have 5 contempt hearings. You're facing 6 months in jail every single time. You understand?
Yes, sir.
You print me out more no driving affidavits, like 20, 50,000. So for now, what I'm going to do is I'm going to take you into custody. I'll appoint your lawyer. I am going to find probable cause. Before you leave here, you will swear to us that you're not going to drive. I'm telling you, with me, the worst thing you can possibly do, get in a car and drive or pick up a new case. As it stands now, you're at no bond on a felony case, so we'll just set you off a week to see what happens upstairs. They gave you a PR bond in this case. I don't know if I'm going to entertain that. I don't know if I'm going to let you keep that when you're on probation for a felony evading and then you pick up another one. I'll talk with your lawyer and we'll go from there. Okay. Thanks.
All right, Judge Page.
I know you don't have.
Mr. Trent, do you have an arraignment?
Yes, I do. Good morning.
Okay, great. Hey, how are you?
I'm fine. How are you?
Good to see you, man. It's been too long.
It's Langin. It's been a while.
18?
Should I bring him up here?
Please.
You see that?
Langin.
Yes, Langin, L-A-N-G.
Got it.
You see that?
Good morning, Mr. Langin. Sir, you're charged with unlawful carrying a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you're not afford a lawyer, the lawyer will be appointed to represent you, sir. Okay.
Yes, Your Honor. So on May 16, 2024, officers while on patrol in Harris County, Texas, observed the defendant's vehicle did not display a front license plate. The officer then turned around and got behind the defendant's vehicle. Traffic stop occurred. Officers got information from the defendant and ran this information. Upon returning to the passenger side, the defendant rolled down the front passenger window. The officer immediately observed an unholstered black Glock in plain view on the center floorboard.
Okay. All right, Mr. Langin, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license? Sir. Do you have valid liability insurance in your name? Sir. Then you're not allowed to drive. I'm making that a
You're not too late, Erica. Don't worry. There's plenty left.
condition of your bond. If you want to drive, you must have liability insurance in your name. Until that point, no driving. You can show Mr. Trent, and Mr. Trent can come up to me and prove to me that you have alcohol. I'll take this restriction off of you. But until that time, do not drive. You will be signing an affidavit promising me you do. If you drive, I'll have a contempt hearing. You'll be facing 6 months in jail every time you drive. Do you understand? So that's the only condition I'm putting on Mr. Trent. You have a lawyer. I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Mr. Trent. He'll tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're playing games and you're ducking and dodging his phone calls, I'll issue a warrant for your arrest. If I have to issue a warrant, you will not get any more PR bonds. All right? So for now, I'm going to have you go to Victoria, sign a reset. We'll have you take your seat in the jury box. I'll get your affidavit, and after that, you guys will be free to go. Okay.
Please. Page 5, Callis, Paul, come on up.
All right. Are you Paul Callis? Mr. Callis, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
April 26, 2024 in Harris County, Texas, officers noticed and observed a vehicle displaying a dealer tag that did not have confirmed insurance. Additionally, the front seat passenger of the vehicle started to reach back for his seatbelt to put it on as they passed the officers in the marked vehicle. A traffic stop occurred. The defendant advised that he was transporting the vehicle and did not have insurance. The defendant, who was the driver, front passenger was Goins. The backseat passenger was identified as Daniel Langin. Defendant Goins was messing with the walkie-talkie and noticed there appeared to be new merchandise from Harbor Freight. The backseat passenger had a Class C warrants. Everybody in the vehicle was asked to step out. Officers got consent from defendant Callis to search, and Sergeant advised it was investigating the Harbor Freight theft that occurred where on surveillance, defendant Goins is seen selecting items passing all points of sale without paying and getting picked up by the defendant in the same vehicle that they were stopped in. Defendant Callis was asked about the items. He advised that he bought them from a person on Facebook Marketplace. The total amount of the stolen items was $343.20.
Did you say the stop was for?
Because it was a dealer's tag on it, and it didn't come back to register insurance.
Got it.
Can you just a little bit sit today? I know you're a witness. Just a little bit. Just a tiny bit to make yourself giggle. Like, just say the word jurisdiction. Just try. Contract.
Okay. That's a good sign. All right. Mr. Callis, I'm going to find that there's probable cause to go forward with the case. I'm now ordering you as a condition of your bond not to have any contact with New Harbor Freight. You understand? I'm also ordering you not to have any contact with the co-defendant in this case, Mr. Goins.
Do we have a case number? Or Goins?
Ready?
Yes.
The 02.
I'll take that if you. I can take that.
Look, 029.
Yeah.
34491.
Okay, you ready?
Call it on money.
I have it.
It looks like they charged them with a felony. Felony theft.
Right.
Yeah. Who was the driver, Kevin?
The defendant.
Okay.
Uh-oh.
Mr. Callis, do you have a Texas driver license?
Here we go.
Do you have valid liability insurance in your name?
Yes.
I want proof before we allow you to drive. But like I said, I'm ordering you not to have any contact with the co-defendant and not to pick up any new cases, no contact with Harbor Freight. What do you do for a living, sir? What do you do for a living?
Driver helper.
How much money do you make a month?
I make like probably about $600-800 a month.
A month?
Sir.
Okay. Did you want to apply for an appointed lawyer, sir?
Yes, sir.
Okay. I'm going to have you get an application. I'll have you go fill out a, can you run his license too, please? Okay. I'll have you sign a receipt with Victoria, and then I'm going to have you take your seat in the jury box. Do not leave until you sign our bond conditions, otherwise I'll issue a warrant.
Yes, sir.
Please. So no contact with New Harbor.
All right,
Or
next one, Judge, is
co-defendant.
page 8, Morales, 1.
Carolyn, can you read that for me? Hi, Kim. I hope that's not a bad word because it looks awesome. Oh, the cat ran over the keyboard. Maybe? Nope. Carolyn will read it for me. I know it.
Okay, Juan Corrales. Yes or no? Sir, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present or questions and interviews. If you cannot afford a lawyer will be appointed to represent you, sir. Okay.
Sorry. Yes, sir. So on May 10th, 2024, officers were dispatched in Harris County, Texas. Complainant stated he was stopped at a red light at the intersection of 6799 and 5901 Bel Boulevard when he heard the defendant yelling at him from another vehicle, which was located in the lane next to him. Complainant stated that the defendant exited the passenger seat of a vehicle and approached his tow truck. Complainant stated that the defendant began to demand that he let the towed vehicle he had down. Complainant stated that the defendant began to climb the bed of his tow truck. Complainant stated that he exited his tow truck and began to approach the defendant. Complainant stated that the defendant continued to yell at him, began to approach him in a combative stance. Defendant said, "You're going to pay for this," as he continued to approach him aggressively. Complainant stated that the defendant was throwing up gang signs and closing in on his personal space. Complainant stated that he was in fear of his life and would like to press charges by making contact with the defendant. He continued to tell officers on scene, "I'm going to fuck you up with my lawyer." The defendant continued to yell racial slurs as officers on scene and acting disorderly.
We learned yesterday that the mask goes down here, buddy. It goes down here. Why is it over this part? The mask goes down here. Just watch my stream from yesterday and you'll see where you put your mask.
Mr. Corrales, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand?
Yes, sir.
I'm also ordering you not to be in possession of any weapons as well. How old are you?
26.
What do you do for a living, sir?
Used to work in construction.
You said you used to?
Yeah.
Why used to?
I got fired.
Because of this? Okay. How do you get money now? How do you eat?
Maybe 6 months I ain't work. I've been looking for a job and stuff, but it's hard here.
How do you eat? It's been 6 months, man.
My brothers at work, they try to take care of me, trying to help me and stuff.
It's time for you to get a job, man. I'm now going to make that a condition of your bond. I don't want you roaming the streets and playing Xbox all day while everybody gets to work and feed you. Come on, man, you're 26. No more. You must get a job. I'm making that a condition of your bond as well. No bumming around anymore. I'm also going to order you not to consume alcohol or illegal drugs, no smoking weed too. Do you understand? If you're not going to play by the rules, I'll keep you with me. It's easy as that. I'm not asking for much, man. I'm just asking to be an upstanding citizen. That's it. I'm not asking to split the atom here. I'll have you fill out an application. I'm going to have you sign a receipt with Victoria. Mr. Corrales, do not leave until you sign our bond conditions. All right. Just don't worry about it because I'm going to have him monitored with Tracy. So,
Tracy.
Yeah. So,
Here, Tracy.
no drugs, no alcohol, no weapons, no contact with the complaining witness, and get a job.
Victoria, I don't know what you're doing. The judge just sent someone over to you. Don't worry, Tracy's got it. Tracy's got it. And Shatora isn't doing anything right now because he's not on probation. But so you're excused. Hi, Victoria.
All right, Judge, page 9. Please speak up. Janoah.
Now, this is an interesting one. So, let's see.
Carolyn. Carolyn, hi, Spud. Carolyn Restraint. I warned you about this.
Okay, are you Carolina Janoah? Miss Janoah, you were charged with an exhibition of a firearm, and it looks like threaten or exhibition of use of a firearm, I guess within a school or school property. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. You cannot afford a lawyer. A lawyer will be appointed to represent you, ma'am. Okay.
You're on May 16, 2024 at the 7500 block of Bissonnette Street on Sharpstown High School, Harris County, Texas. The defendant was detained pending an investigation after a situation began with the defendant pointing a toy gun at people at school, causing a disturbance because witnesses did not know whether the firearm was legitimate or not. While detained, the defendant would not stop saying she was going to bring a real gun and show our officers what a real gun looks like.
How old are you, ma'am?
18.
Do you go to school at Sharpstown?
Yeah.
Are you a senior? What are you?
Senior.
Okay. Not a smart move. You have to be very careful. People think you got a real gun that could go sideways real quick and they start shooting. Ask questions later. Don't say anything. Ma'am, I'm now ordering you as a condition of your bond not to have any guns whatsoever. That includes toy guns. You understand?
Yes.
If I find that you become a threat to public safety, I will do everything in my power to protect the public. If that means putting you in lockup, I'll do it. Why is this funny to you?
No, it's not funny.
You're looking at an entire year in jail, Miss Janoah.
I'm just nervous.
If I drug test you for right now, what am I going to get? If I test you for drugs and alcohol, what am I going to get?
Wait, what did you say again?
If I test you for marijuana, any other drugs, are you going to test positive? It stops today. And I'm telling you, I will test you 30 days from today.
Don't worry, guys. The judge has more in for her. The judge is trying to help her. She's young. He has a chance to help her right now, so he pulls out the big guns.
You say that if you test positive for marijuana in 30 days from today, I will put you in jail and I'm going to make your bond so high you're going to split in 3. You understand? I'm done playing games and it's over. What else do you do in life? Do you work? Who do you live with?
My parents.
Are your parents here today?
Yeah. My mom.
Can you go grab her? Oh, she speaks Spanish?
Yeah.
Okay, just.
You understand English?
Oh, you're great. Come on up. Come up. Hi, Luis. Thanks for coming.
Buenos días, ¿qué tal? Me llamo Luis. ¿Te paras aquí, por favor? Sí, solo mire, si le hablo en español nada más.
Good morning.
Buenos días, señor. Solo hablo español.
Thank you for coming.
Gracias por venir, por llegar.
Do you know what she's charged with?
¿Se la acusan? Yes, hable fuerte.
Sí.
Would you like to hear what happened?
¿Te gustaría escuchar lo que ocurrió?
Sí.
Yes.
Do you mind reading it slow so that she can understand?
On May 16, 2024, at the 7500 block of Bissonnette Street, Georgetown High School, the defendant was detained pending an investigation after a situation began with the defendant pointing a toy gun at people at the school, causing a disturbance because the witnesses did not know whether the gun was real or not. While detained, the defendant would not stop saying she was going to bring a real gun and show the officers what a real gun looks like.
Mom, keep your shoe on. Keep your shoe on. You're in court.
I asked her if I were to drug test her right now, if she would test positive for marijuana. And she said that she would. So.
Hello? She does not use drugs.
Boom. That's what the mom said in reply. She does not use drugs.
I'm going to send her for a drug test right now. But she already told me that she would test positive for marijuana. So tell me, what do? Do you work, ma'am?
Sí. Sí.
Yes.
When you're gone at work, is she by herself at home? Or has she gone out roaming the streets? What does she do?
No.
No?
I'm going to send her for a drug test right now because I want to know everything that's in her system. I've ordered her not to have any weapons. I'm also ordering her to stay in school as well. I will give you a lawyer today so that you guys can speak about how to handle the situation. I've told her that I don't want her picking up any new cases. I don't want any more issues. And I would also like to know with you if she's a problem with you. Does she follow the rules with you? If she doesn't, just let me know and I will try to straighten her out for you. I don't know how it happens at home with you, but if she's a problem for you, I can help you straighten it out.
Kaiser, sí.
Yes, sir.
Sí.
Does she create issues for you at home?
I'm sorry, Your Honor, what's that?
Does she create issues for you at home?
¿Problemas usted en la casa?
No.
No.
Okay. I want to send her for a drug test now because I want to know if she's going to test positive or not. And then after that, I will give you a lawyer today. I'm sending you now for a drug test. You must come back to court after that. If you do not, I will issue a warrant for your arrest. If you do not come back to court after your drug test, I will issue a warrant for your arrest. Do you understand, ma'am? Okay. Okay, ma'am. If you just want to take a seat, I will have you speak to someone here momentarily. Thank you, ma'am.
Okay, she might be the little head that we see later, now that I think about it.
Yeah, we'll give it Tracy.
What inside for your reset? Your reset. All right, Judge, page 12, Hagen, come on
Yeah, I want, no. Yeah, yes, but I want her tested 30 days from today. So she must appear here in 30 days and we're going to drug test her. Make sure she's not using it. Yeah. And stay in school full time. Victoria.
Yes. This is page 12, Hagen.
Good morning, Mr. Hagen. Sir, you're charged with interference with the duties of a public servant. This is a Class B misdemeanor. You're facing 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford a lawyer will be appointed to represent you, sir. Sure. Okay.
Your Honor, on May 11, 2024, officers were dispatched to 3002 Gallo Circle, Deer Park in Callis County, Texas, regarding a disturbance in progress. The defendant was highly intoxicated, being aggressive to family members. Witness had a ripped shirt with blood on it, caused by the defendant by fighting him. Witness 2 was laying on the ground with blood running down his arm and leg, also caused by the defendant. Witness 3 was holding the defendant down on the ground while the defendant was yelling obscenities. Witness Cameron Norville, who stated he was struck in the face by the defendant, which is why he was being held down by witness Chad Norville. Witness Chad Norville stated that the defendant started getting belligerent, yelling obscenity at people and recklessly struck his son in the face. Witness father.
Oh, wait. So he struck another person? That's 2?
The son in the face of Norville. Witness Melvin Fox stated that while he was helping witness Norville hold defendant on the ground, he fell on the ground, which caused him to have a bloody leg and knee. No person stated that they felt pain and they did not want to pursue charges. Defendant pushed himself off the ground and attempted to flee the scene while shirtless with a bloody face and yelling obscenities. Due to the investigation being interrupted by the defendant, officers attempted to prevent the defendant from leaving the scene. Defendant attempted to strike Sergeant Trotty and started screaming that he will be fighting.
Almost tried to strike an officer?
Yes, Your Honor. Screaming that he will be fighting the police. The officers observed the defendant push Sergeant Trotty and other officers before being tackled to the ground. Defendant continued to attempt to free himself by pushing officers while he was on the ground and continued screaming obscenities, which prevented the officers from completing their investigation. Officers attempted to seat the defendant in the patrol.
We need to find the video. We need to find the body cam.
Unit. Defendant continued to kick the inside of the doors, refusing to get inside the patrol car. Officers ended up having to push the defendant inside.
Lucky you didn't get tased. Number one, you're lucky you didn't get 2 assault charges and an assault of a peace officer. You know, there are some people that when they consume alcohol, they turn very happy, like little bunnies jumping in the woods. And then there are people that turn into the flipping devil when they start consuming alcohol. Which one are you? I am now finding probable cause. Not only that, I'm going to order you not to consume alcohol. And I will now give you a breath monitoring device so I know that you're not consuming alcohol. Mr. Hagen, if you have...
I think maybe Carolyn Fozzie can't fix this one. We got to send him straight to Kelly. Kelly, good luck.
An alcohol problem, you better address it, because if you don't, I'm going to do it for you. And I promise you, you're not going to like it. You're not going to like the way that I do it. You understand? You were given a PR bond. Now, that is why you're out. You will not get another one. You violate these conditions, you pick up a new case, or if you don't act like little bunnies jumping in the woods, it's over. I'll put you in jail. No more P. Diddy. Do you understand?
Yes, sir.
What do you do for a living, sir?
Field manager of a cabinet company.
We're going to research the case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign a reset. After that, I'll have you go to Tracy where you get your bond conditions. Don't violate these conditions, because I'm telling you, it's going to go sideways real quick. I will do everything in my power to protect the public, and I don't care if that means putting you in jail. All right. Yeah. That's okay. Yeah. No drugs, no alcohol, random UA, no weapons, and then a portable device, 3 days.
That's such a good idea. Rebecca, give Victoria and Melissa each a taser. The judge better listen. The judge don't listen when she says no kid, nothing during May. And he says, okay, let's do May 28th. And then Victoria has her taser ready.
And waive the fee. Who's next? Okay, hi, you ready? Hi, please. Hi.
Alejandra. I don't know how to say the last name, but it's Medellin.
What does it start with?
M.
M.
She's so nice and pronounced it for me in our 16.
Medellin?
Yes.
Okay, Mr. Medellin.
She's gonna be right back.
Oh, come up, man. Alejandra, oh, sorry.
You say your first name wrong, I say the last name wrong.
Good morning, Miss Medellin. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews. You cannot afford a lawyer. The lawyer will be appointed to represent you. Okay.
Yes, Your Honor. On May 16, 2024, officers observed a vehicle traveling 47 miles per hour in a 35 mile per hour zone in Harris County, Texas. A traffic stop was conducted. The defendant had watery eyes and an odor of an alcoholic beverage on her breath as she spoke. SFSTs, 6 out of 6 clues on the horizontal on HGN, 4 out of 8 walk and turns, and 4 out of 4 one leg stands. DIC was read. She consented to a breath, registered .123 and .120. Defendant is an eligible license and no criminal history.
Okay, that's going to be my next question. Okay, Ms. Medellin, I'm going to find that there's probable cause to go forward with the case. You do have a Texas driver license, ma'am.
Yes, sir.
Do you have liability insurance in your name?
No. Your Honor, it is her parents' vehicles and her parents' insurance. Her parents are listed drivers, but she is driving under them. She's not a listed driver.
Then she can't drive.
Yes,
She needs to be listed.
She needs to get listed. And
You are not allowed to drive.
She said she could speak to her parents and get herself listed as an insurance driver.
When you do that, bring me proof, then we'll allow her to drive. But you are not allowed to drive until you were named as a policy, as you were listed on the actual insurance. If there's an accident and you cream and you kill 5 people, they're going to come after you and take everything that you have. That's why you pay for $30 a month to get insurance so that the insurance company represents you in that instance. So no driving. I'm also ordering you not to consume alcohol or illegal drugs. I will randomly test you. If I find that you're consuming alcohol or drugs, you will go to jail. You will not get any more PR money. You understand? You have a lawyer. Stay in touch with them. They will tell you if and when you have to come back to court. I will waive your appearance so you don't have to waste time coming here, but you must stay in touch with them. If they tell me they can't get a hold of you, I will issue a warrant for arrest. So no driving. If you drove here, you may not drive home. Okay? So we'll have you sign this affidavit now. You'll get the Victoria to sign your reset. You'll get with Tracy for your bond condition. After that, you guys are free to go. And then just bring me the insurance when you have it, and then we'll take this restriction. Okay. Thanks, guys.
Hey, I'm 5'2 3/4. Yes, I am.
This way. This way. All right, Judge, page 1, Spanish speaker.
Okay.
Okay,
I'm ready when you are.
Come on up. Mr. Lindquist.
No, he's in custody. No, that's Burroughs. He's in jail. We had a felony warrant.
Not biological death.
The other one is, I wrote it.
No me dijo con ella, ¿no?
I haven't even done it yet. Give me a second. All right. All right. Jose Tamayo Alarcon.
Yes.
Sir, you're charged with assault of a family member. So you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. Please don't say anything. Okay.
Your Honor, on May 11, 2024, officers were dispatched to 6615 Utah Street, where the complainant ID'd the defendant. Upon arrival, officers observed the defendant driving a white Mercedes and conducted a felony stop at 200 North Sam Houston Parkway because he was a suspect in an assault. The officer stated that he came back from a family lunch and was getting her. The officer stated that he came back from a family lunch and was getting.
Hold on a second. Guys, I can't hear anything. Please keep it down.
Thank you, Your Honor.
And was getting her daughter ready for a family when the complainant and the defendant got into a verbal argument. The complainant stated that the defendant began to pack his things, stopped, and then pushed her with both his hands towards the closet. The defendant put his open palm on the CW's face and pushed her all the way back until her head hit the wall. The complainant stated she was able to put her hands up and shove the defendant and run out of the house. The complainant stated she felt pain to her face and had visible injuries on her right cheek. There is previous criminal history, assault of a family member back in 17, out of 14, that was ultimately dismissed. The federal case of smuggling aliens, ICE, that was August of 14, 36-month probation. Then there's
Is he on probation now?
that was back in 14. That was 14. This was 36-month probation. I don't think that's current now. I think that was 36 months back in 14.
Any more criminal history?
And then there's an alien inadmissibility. That's an unknown disposition out of Miami.
Mr. Alarcon, I'm going to find that there's probable cause to go forward with your case. I am ordering you now not to have contact with the complaining witness in this case. Do you understand? I'm ordering you not to consume alcohol, illegal drugs. I'm going to randomly test you. I'm ordering you not to be in possession of any weapons as well. There's a protective order that was issued on the 12th of this month. I suggest you get to know it. If you do something to violate that protective order, the state can and will file a violation of a protective order against you. That's one of the worst cases that you can pick up, because if you violate those conditions, I can hold you at no bond. And I will do it in a heartbeat to protect the public. Do you understand? When I mean no contact of any kind. Emails, messaging, Snapchat, phone calls, WhatsApp. Do you understand?
Drive-by shootings.
I understand. Yes.
He has a prior assault against the same person, so that's why I'm ordering now no contact whatsoever. I don't care if she wants contact. I'm just ordering you not to have any whatsoever. You
Good
have a
job,
lawyer.
Judge. Good job.
It's your responsibility to stay in touch with them. If they come back to me and tell me they can't get a hold of you, I will issue a warrant. You will not get any more PR bonds. If you violate these conditions, you pick up a new case, I'm telling you, I'm gonna make your bond so high, you're gonna flip. You understand? Okay. I will have you go to Victoria, sign a reset. After that, you'll get with Tracy for your bond conditions. And after that, you'll be free to go.
Thank you, Your Honor. Rather still Marino Jr., hopefully we can deal with that.
So one thing, let's get him out. She's been a little busy, so I don't know if she's had the time because she had to get in contact with.
Now it's 46 pages.
Yeah. Okay. Yeah, send it to me. Let me take a look. She must have sent, Mr. Gold, she probably sent the entire,
Yes, I'm not sure what the violations were. All I knew is that his schedule was not consistent, but now it is, and he understands he cannot miss it.
I don't care.
I understand.
Like, I don't, that's something that you have to address before the fact. You don't address it after.
Now, Your Honor, that was his first violation. It would never happen again. And this isn't a DWI, it's an AFM, but it's still very serious. We fully understand.
Let me know who you are.
Do you have any more arraignments? Let me finish your arraignments first. I will print this out. What's your email? Let me forward this to you.
elgarzalawfirm@gmail.com. elgarzalawfirm@gmail.com.
I'm sending it now so you can look to see when the blows are not. If you don't have time.
I just have court. That's why I was trying to take care of this.
Go do what you need to do. Come back.
All right, Judge, page 21, Perez, come on up.
Alexis?
Yes.
Yeah. Are you Alexis Perez? Yes, Your Honor. Mr. Perez, you were charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford a lawyer will be appointed to represent you, sir. Please don't say anything.
Your Honor, on May 15, 2024, also we're conducting a traffic stop, traffic enforcement at the 10500 block of Former Market, 1960 Road West in Harris County, Texas. And observed in the car speed radar to show a speed.
Donald, the guy who threw a tire covered that little seal or a clock with his head. He covered the seal.
101 miles per hour. And then they observed the black Chrysler 300 traveling at a high rate of speed going eastbound in a 40 mile per hour zone. Officers engaged their lights and sirens and attempted to catch up to the vehicle and observed the vehicle changing lanes several times without signaling and still at a high rate of speed, cutting other motorists off, causing them to brake to avoid collision. Continued at a high rate of speed, the vehicle turned off its lights and turned into a business parking lot at 9351 FM 1960 Road into a McDonald's parking lot. When the vehicle turned into the parking lot, the front right tire hit the curb, causing severe damage, rendering the vehicle inoperable. The vehicle was unoccupied at the time the police caught up to it. Officers observed a male walking southbound on Perry Road away from the vehicle location. An anonymous bystander called stating that a male with a red backpack, white shirt, and shorts was seen exiting the vehicle. The male observed walking matched the description of the driver provided by the caller. The defendant was stopped approximately 400 feet from the vehicle and identified as Alexis Perez. The defendant stated that he was the driver and he attempted to avoid being caught by police because he was scared and had ran from the police in the past.
Snitches get stitches.
Mr. Perez, I'm going to find that there's probable cause to go forward with the case. How old are you? 19. What do you do for a living? I put. Do you have a Texas driver license? Sir. Do you have liability insurance in your name? Sir. I want proof before I allow you to drive. And let me tell you something. If I ever find that you drive like this again, I will put you in jail so fast you're going to lose your hair like me. I'm telling you, you ever drive like this again, I'm going to make your bond so high. You will be signing an affidavit with me today, promising me that you will not do any donuts, reckless driving, racing, participate in any street takeovers, anything like this. And if you do, I will have a contempt hearing. You'll be facing 6 months in jail every single time. I will tell you now that the legislature in Texas has made it extremely easy for district attorneys to take and seize people's cars for people who participate in this kind of action multiple times.
I seize cars every day. I seize them out there right now.
You've already told them that you've done this multiple times. If they catch you again, it's very possible they seize whatever car you're driving and take it from you permanently. You understand? Great. Thank you.
Jamie, check out my Discord because I have Chrysanthi, that lawyer from right where you are, the Australian lawyer, greatest of all time. And I got a whole bunch of her on my Patreon. Did I say Discord? Hold on. I meant Patreon. I picked the wrong one. Go to the Patreon and look at your lawyer. Look at her represent.
This is a promise that you're going to make to me. And if you violate this promise, like I said, I will have a contempt hearing. Every action is an offense in and of itself. You understand? Oh. Did you want to apply for an appointed lawyer, Mr. Perez? You're going to go hire a lawyer? Okay. I'm going to have you come up here, swear to us that you're not to participate in this action again. I'll get you to Victoria to sign a reset and we'll get you out of here, sir.
Judge page 24, Reynoso, come on up.
Kate, can you file that on Mr. Perez too? Hey, Victoria,
Yes.
I would also like him to sign bond conditions from the state as well, please. Yeah. So can you, street takeovers, reckless driving, donuts, racing, and all that jazz. Yeah, please.
What's your last name?
It's Anthony Reynoso? Are you Anthony Reynoso?
I'm sorry.
Anthony. Okay. All right. Mr. Reynoso, you were charged with assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews in the state of Texas. You cannot afford a lawyer. A lawyer will be appointed to represent you, sir. Is he going with you? No. He's not allowed out. Okay. All right, please.
On May 15, 2024, at Sharptown International School in Harris County, Texas, officers responded and spoke to and complained witness, a juvenile male, age C14, He had visible injuries and bruising to his forehead. Where he informed officers he was in the restroom when the defendant, Anthony Reynoso, and 7 other students approached him. Anthony Reynoso began to punch him in the head and stomach area. AC also sustained visible bruising on the abdomen and side with small scrapes on his ring finger on both left and right hand. On the video, the administrator retrieved from the student in a scene where AC falls, the complainant falls to the floor, and Reynoso stands over him. Complainant punching over him, which is the complainant, punching him in the face and body with closed fists as Cruz balls up on the floor. Reynoso then stands over the complainant as he is on the floor and stomps him in the face with his right foot. Officer Sanders spoke with Reynoso where he stated he approached the complainant in the restroom with his friends. Reynoso stated he punched the complainant and his friends stood there watching. Reynoso then stated that the two fought by the front office, but do not remember using his feet to kick or stomp.
Did the person go to the hospital?
What was that?
Did the person go to the hospital?
No, it's not clear from the record.
First thing we're going to do, Mr. Reynoso, is I'm sending you for a drug test right now. I want to know everything that's in your body. Take a seat for me at the jury box. Okay.
Tylenol, ibuprofen, Tums, meloxicam.
Me too.
Next one, judge, is page 24, Rivera. Come on up.
Oh, is this the co-defendant?
No, judge. For Reynoso?
Yeah, I have a co-defendant.
Yeah, this is our first setting with him. He's got,
No, this case, he's got the aggravated assault, felony assault, another aggravated assault of a pregnant person, and now we have the assault as well. A fifth.
Judge, are you saying there's a co-defendant on Reynoso or Rivera?
On Reynoso, there.
Well, the information doesn't show me that.
We'll get there because I want to drug test him first, and we'll get to dealing with him later. He made a surety bond. So that's what this is. So this is Kavita's case, and it's older than Jesus. So I need to talk to them in Slider, see what we're going to do. Take a seat for me in the jury box. You're not allowed to leave.
Well, I didn't,
Take a seat for me in the jury box. I'm not going to talk to you without your lawyer.
All right, Judge, page 30, Thompson.
Dominic Thompson, come on up. Mr. Thompson, you were charged with assault of a family member. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present and questions and any views of the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
On August 22nd, 2023, the defendant picked up a complaining witness, which is his girlfriend, from work. They began arguing in the car. Defendant punched the complainant in her left eye, causing pain and swelling. Complainant called 911 while still in the car. Defendant drove to the complainant's house and left on foot. Complainant went to a police station to file a report. Complainant ID'd the defendant as the man who assaulted her. Criminal history, driving without a license. 2020, that was dismissed. Carrying a handgun and motor vehicle was ultimately dismissed out of court 10. Failed to ID the police officer. False information, court 14. I think that was 25 BHC.
Okay. Mr. Thompson, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license? You want his license, please. Do you have valid liability insurance in your name?
Hang on a call. Yeah, Alexis.
I guess we'll find out whose car this is. If you don't have liability insurance, then you're not allowed to drive. I am making that a bond condition. Do you understand? I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons.
All these cases in all the courtrooms, in all the states, you know, it really hits home how many people out there are driving without insurance. Like, every time we get on the road, we should, you know, you guys, we really got to get the better insurance, the insurance that covers like everything, because nobody has insurance. I have insurance. Like, if you don't have insurance, I think I was late on a payment last year and I had like no insurance for like 3 days, and they sent all these letters to the Department of Transportation, and they were going to suspend my license if I didn't fill out this form saying I didn't drive my car within these 3, and that was just 3 little days. Guys, you have to get insurance to cover the other car too, because nobody has insurance.
It looks like a protective order was issued on the 16th of this month, Mr. Thompson. I would get to know it. If you do something to violate the protective order, the state can and will file a violation of the protective order against you. It's one of the worst cases you can pick up in misdemeanor court. You understand? We're going to reset your case to give you time to hire lawyers. So I will first have you go to Victoria Center, reset. After that, I'll have you take your seat in the jury box. I'll get your bond conditions. We'll have you sign it, and then you'll be free to go, sir. Don't pick up any new cases while you're on bond. Otherwise, you know what happens. Okay, please.
See that, mods? I got my link in there with a broken hand. I got my link in there. I broke my hand on Sunday. And it hurts.
Page 31 and 32, Villarreal.
Natalie Villarreal.
Yes.
Ms. Villarreal, you are charged with assault of a family member. You're charged with 2 other counts of assault, bodily injury. So all in all, you're facing 3 counts of assault. You're facing a year on each of those cases. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you're not afford a lawyer will be appointed to represent you, ma'am.
On May 10, 2024, officers were dispatched to 1520 Texas Street in reference to an assault. Officers met with complainant 1, who stated that his ex-girlfriend, defendant, hit him with a closed fist to the head, causing pain. Complainant 1 ignores the first assault, but the assaults continued when the defendant hit him with a shoe in the head, causing pain. Complainant 1 left the vehicle they were in, and the defendant met a water bottle to strike him. Sorry.
Okay.
That they were in, and hit him with a metal water bottle to strike him in the left cheek, causing a minor cut and causing pain. Complainant 2 stated that the defendant also scratched him on the forehead, chest, and back, causing pain and cuts. Complainant 3 stated that the defendant's friend tried to fight the complainant 3, but the defendant came from behind, pulled on the crown of her hair, and threw her to the ground, causing pain. Complainant 3 is also a witness to the scratches to complainant 2. The defendant was ID'd by her Texas driver's license. There's no criminal history.
Do we know if alcohol or drugs was this a part in this mailing? Has she been using? I think that I'm going to do that regardless, just to make sure it's not an issue. Ma'am, I'm going to find that there's probable cause to go forward with your case on all 3 cases. I'm ordering you not to have contact with any of the complaining witnesses in all 3 cases, not to be in possession of any weapons, and not to consume alcohol or illegal drugs. I will randomly test you. If I find that you're consuming alcohol or any kind of illegal drug, you will go to jail. You will not get any more PR bonds. You understand? You have 3 cases. So imagine if I have to revoke your bond and set your cases at $15,000, if you have no one to bond you out, what happens? You're stuck like Chuck in jail until these cases are over with. And I'm telling you, that could be the better part of a year. So I would behave yourself while you're on bond. Otherwise, it's over. How old are you, man?
22.
What do you do for a living?
A waitress at Sawgrass.
How much money do you make a month?
I just started the job. I just finished my training process, so I'm not sure how much.
Who you live with?
My parents. Yes. Yes.
Apply for an appointed lawyer, man.
No.
You're gonna go hire a lawyer.
Wait, sorry?
Are you gonna go hire a lawyer?
No.
You need a lawyer to represent you, man. I was offering you the opportunity to apply for a court-appointed lawyer.
Yes, I'll take the offer. No.
Okay. I don't want any more issues, man. You understand? This is your first time in trouble, and I'm telling you now, you're young, you're digging yourself into a hole that could potentially really impact you, because when people see this when you're applying for jobs, you think that they want someone like this working for them. Right, because they know that trigger temper, boom, you're just gonna unload. Be careful, man. Deputy Lopez will give you an application. I'll have you go to Victoria, sign a reset, and then you'll get with Tracy for your bond conditions. Do not leave until all of those things happen. Please.
I just don't want to ever go to Victoria and sign a reset. I just don't want to do that.
33, Witherspoon, come on up.
So I stopped it there because this stream is already 2 hours and 30 minutes long. But all my pro stays were so nice. I didn't want to cut any of them out. I couldn't give them up. I couldn't give the entitled guy up. I couldn't give the serious bodily injury up. I couldn't. I had to have all of it. I wanted it all. So I put it all in. Now I have minutes before court's open. Minutes. So many, I'm going to take a nap. I did take a nap. I got off work last night and I was so tired. I put the chicken on the stove and then I went upstairs to look at my court videos, and I went through a spot of a really boring judge, and boom, I fell right to sleep. But my alarm woke me up. I mean, the smoke detector. The smoke detector absolutely woke me up today. I never burn anything. My cooking is so good. I'm telling you, my cooking is so good. My chicken pot pie, and it's not like the crust on the top. It's real chicken pot pie. I'd slap your mama good. I mean, it's so good. Well, today the chicken is blackened chicken out there. The whole house smells terrible right now. I got incense here somewhere. And it's just not helping. Nothing's going great today, lately. It's just these little things where I break my hand and I burn my dinner. I didn't get a flat tire, so I should be happy, but chicken pot pie, pot, Potpie, chicken pot pie. So, Carolyn, a lot of people make chicken pot pie, and what it is, it's the pie, with the crust on top, and then the chicken and potatoes and whatever they put in it, and the gravy like inside, like a big pie. But no, in Pennsylvania Dutch country, we make chicken pot pie where it's like a stew, and the dough is actually these little squares in with the chicken and the potatoes, and it's really good. I mean, it's really, really good. Melissa, Victoria, I hope you guys have a great day at work. I know it's Friday, so you guys are in for a day, but don't worry, we'll be watching. I'm going to find out, Mika. I'll find out if charcoal chicken is okay. I'm going to go eat some because I'm an 80s kid and we ate what we cooked. We didn't throw it away. We ate it. You too, Victoria. Have a great day. Victoria, check your mail today. It's a box. Oh, a recipe? I just put stuff in with my heart. I don't even know. I put my heart in. Yes. It is lovely to spend time with all of you Vibers. It's so much fun. But I hope you have a good day. I am going to go get ready for court. I'm going to dye my hair today too. I'm going to go get ready for court and dye my hair today, and in that order. Thanks for coming out, guys. I really appreciate it. I do. And I'll see you again soon. Bye.